Hello, everyone. Welcome to a new episode of Immigration Fridays. I am your host, Prashanti Vedi, and we're here again to explore the ever evolving landscape of US immigration. So, what's on the agenda for this week's episode? And this week, we will discuss the new H1B regulations and how that changes things for employers filing for this cap season. Let's first talk about the bona fide employment requirement. At first glance, there's no information indicating that the court decision, that is IT Serve Alliance Inc. versus Cessna, has been altered in any way by these new H1B regulations. Just to give you some background, in this 2020 case, the US District ruled against USCIS, and they said that the USCIS policies that had been imposed were too stringent, and especially with reference to employer-employee relationship and with reference to the itinerary requirement. It was too stringent and it was against regulations. So, following the court decision, USCIS issued a memo and they agreed to rescind these restrictive policies and to reopen some of the cases that were denied due to these policies. They, however, said that they could still request documentation for bona fide employment. That's what we're talking about, bona fide employment, if anything has changed in the new regulation. So even at that time, the court decision said that they could still request for documents in order to show that the job was not speculative and that the company had a bona fide specialty occupation work available for the beneficiary. But however, in practice, since 2020, USCIS has not been asking for end-client letters, purchase orders, contracts, MSAs, and even the Department of State, the consulates, were asking for it. They took a while to change their practices, but they had stopped asking for client letters as well. But with this new regulation, they specifically say in the regulation that the employer has to show that they have bona fide employment for their employee, they have enough specialty occupation work, and if it's a consulting company, then they should submit documents such as client letters, POs, work orders to show that there is sufficient specialty occupation work. The second and most important change has also been some clarification and some changes with reference to specialty occupation. USCIS has clarified that you have to show that a bachelor's degree is required in a specific major by most employers, but you don't have to show that all employers require a bachelor's degree. So as long as you show that in the industry, a majority of the employers require a bachelor's degree, even if some employers don't require a bachelor's degree, it's fine. So they clarified that because that has always been a controversial topic, because they would look at the Occupational Outlook Handbook to show what the industry standards are, and in the Occupational Outlook Handbook, if the job description said that some employers don't require a bachelor's degree, then USCIS would quote the Occupational Outlook Handbook and then deny cases based on that single sentence. USCIS also clarified that a bachelor's degree is required in a specific field, but it does not have to be one field. It can be several fields as long as they show that each of those fields is related to the job description. What does this mean? Say, in a software engineer position, if a bachelor's degree is required in computer science, information systems, math, that's fine. Again, if the OOH says that, or DICE or Monster says that a bachelor's degree is required in any of these fields, as long as you can show that each of these fields, math, computer science, information systems, is related to the job description, so let it be. I mean, it's still a specialty occupation. So there was no restriction on it being just one single major. An important change. Now, these two things that I talked about previously have always been in the horizon, and USCIS says that they're just clarifying it. But one major change that they've made is that they have said that in order to show that the position requires a bachelor's degree, we have to look at the end client requirements, not the employer's requirements. So even if the employer's website shows that they have placed an advertisement, and then in the advertisement they've shown that a bachelor's degree in computer science is required for a particular position, you have to actually go to the end client's website, or get a letter from the end client showing that the particular position that the employee is working on at the end client site requires a bachelor's degree in computer science. So again, they're reiterating the fact that most probably end client letters would be required, or some information would be required from the end client to show that a bachelor's degree is required for the position. I hope with that I was able to give you an overview of the changes that you need to be aware of with reference to the new H1B regulations. With that, it's a wrap for this week's Immigration Friday episode. Immigration laws can be complex, so if you need legal help, please reach out to us, prashanti@reddyesq.com or 212-354-1010. With that, I'm signing off and looking forward to another exciting episode of Immigration Friday next Friday. Thank you. Stay tuned.